Good afternoon.
Good afternoon. Great to see you, Oumar. How are you?
Good to see you. How are you? How's Gainesville?
We are fine.
Good.
It's a great day. I'm sure it's similar in Atlanta. So, okay, Todd is here somewhere. He just got on. Todd usually does a little, very quick intro, and then I'll do a welcome and introduce you. Is that your email account? That's Todd's email.
Which one?
Got it. I'm seeing a few things on the screen.
That's probably Todd.
So with this Zoom webinar, you may be aware, you're not going to see us. So you're pretty much talking to your screen, but already, there's a dozen attendees and people will come in. And then during the Q&A, we can unmute them. And so people can ask you questions directly.
Okay, perfect.
Give them a couple more minutes.
Okay.
Damn it.
I think Todd's trying to find a slide.
Okay, it's 3:30. We're going to get started with the Baraza for this week. For those of you that haven't joined us before for Baraza, we will only take questions at the end after the presenter is finished. Oumar will go for plus minus 45 minutes, and then we'll have about another 45 minutes for Q&A or comments from the floor. We will definitely wrap up by 5 p.m. at the latest. And we'll take questions by using the raise hand function. I'll call on you and ask you to unmute in the order that the questions come in. At this point, I'm going to ask the director, Brenda Chalfin, to provide an introduction for Oumar.
Hi, everyone. Welcome to Center for African Studies, Baraza. I'm very pleased to introduce Dr. Oumar Ba. He is an assistant professor of political science at Morehouse College in Atlanta. I also hear through the grapevine that he's heading to Cornell University to take a new position there. So a big congratulations on that. Dr. Ba earned his PhD from the University of Florida in the Department of Political Science just a few years ago in 2017. He studied international relations and comparative politics and was a very active member of our African Studies program, including teaching Wolof for several semesters. He has 2 masters, one in international affairs, another in political science from Ohio University, and he earned his first degree in geography in Dakar at UNICAD. So he came to UF with a lot of experience and focused very broadly on comparative cases around the International Criminal Court in Africa. He has a new book It's just out with Cambridge University Press, 2020, States of Justice, the Politics of the International Criminal Court. Dr. Ba has published in many journals, African Studies journals, IR journals, on topics of human rights, international justice. He has some very new work on cultural heritage and crimes against cultural heritage, as well as justice and political narratives. So it's a very broadly conceived approach to international justice. He's also a public intellectual and is frequently seen in Africa as a Country, where he writes on a wide range of African issues, whether it's Chad, Cote d'Ivoire, Gabon, Kenya. He has a voice in these more public discussions. I'm excited to hear his talk today, Peace, Democracy, and Prosperity for All, Africa and the International Legal Order. Thank you, Dr. Ba, for joining us, and thanks to you in the audience for spending your afternoon with us.
Thank you, Dr. Chalfin, for this very generous introduction. Thank you also for inviting me back at the University of Florida Center for African Studies. My thanks to Todd also for facilitating this invitation. It's good to be back to what was my home and is still my intellectual home back in Florida. I thought instead of talking about the book, to instead center my talk this afternoon around some work in progress that I'm working on right now, and which is titled Peace, Democracy, and Prosperity for All, Africa and the International Legal Order. This is part of a broader project that I have regarding world making and the international legal order from the Global South perspective. And it's located within historical analysis and some archival materials. The scholarship on the relationship between African states and the International Criminal Court tends to point to various contentions that are stemming from the quasi-exclusive focus of the court, the ICC, on the African continent and its citizens, and also the disputes regarding head of state immunity between African states and the court again. While it is also often pointed out that African states were early and eager supporters of the international criminal justice regime, I argue that the current international legal order is starkly different from the one that African states had envisioned. I return to the 1980s and the 1990s and revisit the archives of two pivotal moments in the establishment of the current international legal order. The first one is the work of the International Law Commission, the ILC, in drafting the Code of Crimes Against the Peace and Security of Mankind. And the second one is the negotiations that led to the draft statute of the ICC, the creation of the ICC, in other words. Doing so, going back to these archives, I contend that we find that ultimately African states supported an international legal order that spoke to their concerns, their fears and anxieties, as they saw that avenue for redress amidst a deep mistrust between Africa and international law. And here I put international law in quotation marks. For the ICC, for instance, Delegates from African states sketched a vision of a court that would be truly universal, independent, anchored in an horizontal and consent-based relationship with national jurisdictions, and upholding sovereign equality among all states. Ultimately, the code that was to come out of the Rome negotiations would help usher in an egalitarian international system that protects weaker states and provides a check against great powers. The African agenda, as it related to an international court, was anchored by a desire to restructure international society and usher in a new global order. African states called upon the UN to, quote, facilitate the birth of a new world order of peace, democracy, and prosperity for all, which is where the title of this paper comes from. And this quote is by Nelson Mandela during his address at the UN General Assembly in 1995. A nascent international court, independent from the influence of great powers, African states believe would help rectify the structural inequality of the international system. For African states, establishing the ICC was never merely about trial justice, but rather an opportunity to bring in a new global order. I use archival research and an analysis of meetings, deliberations, and reports spanning the decades from the Nuremberg trials at the end of World War II, where the current international legal order started taking shape, to the end of 1998 Rome Conference that consecrated the creation of the ICC. More specifically, this analysis focuses on two pivotal moments of intense deliberations and negotiations. The ILC, International Law Commission's work in elaborating the draft code of crimes against the peace and security of mankind from 1983 to 1996, and the negotiations before and during the Rome Conference from 1993 to 1998. For the former, I focus on the attempt by African states and the Global South more generally to broaden the list of international crimes and codify colonialism as one of those crimes to the opposition of Western states. For the creation of the Rome Statute, that is the founding document of the ICC, the analysis shows that African states had envisioned a truly universal court that would be independent from the Security Council and also independent from undue political pressure from powerful states. But ultimately, African states envisioned an international legal order that would rectify the inequality of the international system. Now I'll focus on the primary aspect, the first aspect of this presentation, which is the creation of the draft code of crimes against peace and security of mankind between 1993 to 1996. And this was a task that was undertaken by the International Law Commission, which is made of international legal experts that are elected by the UN General Assembly. And their task was primarily to, regarding this draft code, their task was, because the ILC's work is much broader than that, but specifically for the draft code, the task was to codify the most serious crimes of concern to the international community as a whole. How did the ILC come to define and codify the most serious crimes of concern to the international community as a whole. And this is a code, this is the specific language that was used, codifying, quote, the most serious crimes of concern to the international community as a whole. And the document was called the Drafted Code of Crimes Against the Peace and Security of Mankind. It was adopted, the final version was adopted in 1996. And the final version included only 4 core crimes. And these were deemed by the ILC to represent the most serious crimes of concern to the international community as a whole. And the 4 core crimes were genocide, war crimes, crimes against humanity, and aggression. These 4 crimes were the same ones that were defined at Nuremberg, except for genocide, which was not codified until 1948. Moreover, these 4 crimes also found their way into the Rome Statute in 1998. These are the same 4 core crimes that are in the founding document of the ICC. And the ICC being the pinnacle of the international legal order. In this sense, then, we see here a linear conception of which crimes constitute the most serious ones. So from Nuremberg's to the ILC's codification of these 4 crimes to these same 4 core crimes of finding their way into the Rome Statute that created the ICC. And this is oftentimes spoken about as the yellow brick road from Nuremberg to The Hague, as if it was just a linear evolution of how international criminal justice reached its pinnacle with the ICC. Yet I contended that this was not a linear road at all. In fact, there were many bifurcations, many stops and false starts, especially as African states and states from the global south in general try to steer the international community and usher in a different international legal order. Regarding the drafting of the code of the most serious international crimes, I focus here on the efforts at the ILC to codify a specific type of crime, which is colonialism. The efforts to include colonialism in the list of crimes at the drafted code. So to codify colonialism as an international crime of concern to humanity. This effort was ultimately defeated and the code was mutilated in the name of what Kelly Jo Bluen referred to as, quote, settler imperial kinship. And here I want to acknowledge the excellent research done by Kelly Jo Bluen on the drafted code of the ILC. The end result was the absenting of colonialism from the architecture of international criminal justice by removing colonialism from the list of the crimes. And this goes at the heart of an enterprise to resist the project of the Global South, because it is African states in the Global South that were pushing to make sure that colonialism would be part of the list of the core crimes in the draft code. But it is not just a colonialism that was removed from the list. Other crimes such as apartheid, the threat or use of nuclear weapons, and the use of mercenaries were also removed from the final version of the code. So between 1983 and 1996, when this code was being put together, there was a window during which that seemed possible. It seemed possible to have a code that included these crimes as international crimes. Under the impulse of commissioners from the Global South and Dudu Cham as special rapporteur for the drafted code, the ILC took seriously the possibility of codifying colonialism as one of the core crimes in the draft code. But again, that effort was ultimately thwarted by Western states. The first reading of the drafted code that the Commission issued in 1995 included 12 international crimes: aggression, threat of aggression, intervention, colonial domination, and other forms of alien domination, genocide, apartheid, systematic or mass violation of human rights, exceptionally serious war crimes, recruitment, use, financing, and training of mercenaries, international terrorism, illicit traffic in narcotic drugs, and willful and severe damage to the environment. Note that the final version would have all these crimes removed except for the 4 that I talked about earlier: genocide, war crimes, crimes against humanity, and aggression. But this longer list of 12 international crimes is also basically the same one that African states will put back together in the Malabo Protocol in 2014 when creating the African Court of Justice. In 1993, 24 predominantly Western states provided comments on the draft code. And they eviscerated the article on colonial domination, among others. They opposed it so vehemently to the point that in the second reading of the draft code, the Commission had bowed to the pressure, slashing colonialism and 5 other articles from the code. And the final version of the code, adopted in 1996, would be further trimmed down again, and the only 4 remaining would be aggression, genocide, war crimes, and crimes against humanity. How do we make sense of the 13 years between 1983 and 1996, from the first reading of the draft code to the final version of the code that had removed all the crimes except for the 4 that remained? Well, this was a period of intense deliberations that saw tremendous efforts from the African states to steer the ILC towards the codification of a list of crimes that were important to them, and highlighted a vision of an international legal order that would speak to their experience of subjugation and redefine the meaning of serious crimes of concern to the international community as a whole. One of the key architects of that effort to include colonialism in the draft code was Senegalese former Minister of Foreign Affairs, Doudou Thiam. Thiam was a member of the International Law Commission from 1970 until his death in 1999. Prior to that, he was former minister. He was the Minister of Foreign Affairs in Senegal. At the ILC, Thiam served as special rapporteur on the draft codes. And during that time, he produced 13 reports. As a special rapporteur, Thiam was determined to include colonialism as a core crime in the code. Thiam argued that, quote, slavery, aggression, colonialism, and apartheid fall under the category of crimes under international law stricto sensu, which comprises crimes that assail sacred values of principles of civilization, end quote. As such, Thiam presented the inclusion of colonialism in the code as a given, something that is beyond debate. In fact, Thiam's position reflects his broader intellectual trajectory as an African diplomat and a legal expert who sought to help create an international legal order that spoke to the concerns of the Global South. 2 decades before he was appointed as special rapporteur at the ILC, Thiam had published a book titled La politique étrangère des États africains in 1963, wherein he asserted that African states, quote, must continue to seek a way of their own if they are to avoid the risk of being divided between the two world forces. So this was the Cold War, of course. He continues, quote, "If salvation is to be found in Cold War neutrality, it must not merely be a technical posture, but based on solid ideological foundations. In fact, it should be an alternative policy based on a particular ideology and deriving from conditions peculiar to Africa," end quote. Cham was also a strong advocate of the new international economic order. He was also the Minister of Economy of the Federation of Mali, right at the independence of Senegal and Mali. So he was a big proponent of the new international economic order. He called for an, quote, economic bundle in his address to the UN General Assembly in 1967. For Cham, the global redistribution of wealth is not just a moral duty, but rather a legal obligation. So 2 decades later, as special rapporteur, Cham pushed for a code of international crimes of concern to humanity as a whole that would encompass the African experience and especially the crime of colonial domination. Cham's proposal to include colonialism in the code obviously faced the opposition of Western states. For instance, the commissioner from the UK contested the legal character of colonialism. The US commissioner argued that the term colonialism was, quote, political and emotional rather than legal. And when states were invited to offer their comments to the commission's report, the pushback from Western states was swift and unrelenting. The US described the article on colonialism as, quote, vague and too broad. The UK regretted, quote, the introduction of what are little more than political slogans into a code intended as a legal instrument, end quote. Facing so much resistance, Cham, in completing the second reading of the code in 1995, proposed a revised draft wherein he had removed colonialism, along with the threat of aggression, intervention, apartheid, mercenarism, and severe and willful damage to the environment. This move, in turn, met significant resistance from African states that called for colonialism to be reintroduced in the draft code again. Sudan's commissioner regretted, for instance, that some members of the commission were, quote, missing the point that there had been hardly any other acts in the history of mankind which have caused so much misery to millions of underprivileged people and which were almost universally acknowledged as crimes, end quote. The commissioner from Algeria argued that colonialism was not a thing of the past and that it could resurface at any time. In any case, by the end of the 1995 meeting of the ILC, only 4 crimes were remaining in the draft code: genocide, war crimes, crimes against humanity, and aggression. In the end, the failed attempt to include colonialism as crime of international concern in the code is symptomatic of the erasure and omission that characterizes the international legal order. It is a reminder of the robustness of the Nuremberg to the Hague narrative. The debates surrounding the drafting of the code would also find their echo later in the deliberations that led to the creation of the International Criminal Court during the negotiations at the Rome Conference, as African states once again tried to usher in a different kind of court than the one that came out of Rome. So what kind of court did African states want? What version of the International Criminal Court did they propose? I focus here on the negotiations of the drafted statute of the ICC and the negotiations during the creation of the court between 1993 and 1998. Interestingly, in the 1970s already, African states had contemplated creating a regional criminal court during the process of codifying the African Charter on Human and People's Rights. But that project was shelved pending the International Penal Tribunal that the UN General Assembly had envisioned in the Apartheid Convention. African states regularly participated in the ad hoc committee and the preparatory committee for the creation of the ICC, to the extent that between 1993 and 2003, 34 African states, so that's 64 of the continent, 64% of the continent, addressed the issue of the establishment of an international criminal court at the UN General Assembly Sixth Committee. So this is the UN General Assembly Committee in charge of international law. While negotiating the creation of the ICC, the potential for abuse of the international justice regime in which the court would be a central instrument was not lost on the African delegates. African states made various demands relating to the kind of court that they wanted to see come out of the negotiations. Arguably, the major feature that African states wanted to see in the nascent institution was a court that would be independent and impartial. For instance, prior to the Rome Conference, Senegal hosted an African conference in favor of the establishment of the International Criminal Court. The resulting Dakar Declaration reaffirmed the need for the future ICC to remain independent, operating court without being prejudiced by actions of the Security Council. The court's independence and impartiality was also, quote, not to be affected by the method of financing, end quote. In Rome, various African national delegations stressed on the need for the court to be permanent, independent, and impartial, but also free from interference from the UN Security Council and powerful states. The court should also, according to African states, be the judge of its own jurisdiction. Three main themes emerged out of the study of the deliberations regarding the creation of the court between 1993 and 1998. The first one is universality. African states envisioned a truly universal court, which meant worldwide membership and acceptance. For African states, the universality also meant ensuring the widest participation and geographical representation in the negotiations and the drafting of the Rome Statute. At the UN General Assembly Sixth Committee meetings, universality was a recurrent theme from African delegates. And here I want to also acknowledge the excellent work that Lion Giselle has done doing a content analysis of these deliberations. We find that during these negotiations, what African states meant by universality started even at the negotiations having to be inclusive, having everyone at the table while the states are trying to think what kind of court should come out of these deliberations. For instance, the Senegalese delegate said that, quote, universal jurisdiction should be recognized over core crimes even in regards to states that are not party to the Rome Statute. Malawi summed up this view also very succinctly when the representative from Malawi said, quote, "The principle of universality, crucial to the proper functioning of the court, could be achieved only with the participation of all the stakeholders at all levels of the process, including the important preparatory phase." Egypt similarly stated that, quote, "To ensure the universality of the code, as many countries as possible, particularly developing countries, must participate in the drafting of the statute." Kenya said, "The ultimate goal of the new international effort should be to establish a code that was effective, enjoying universal acceptance, and meeting the highest standard for justice and fairness." The Kenyan delegate also said that the continuing absence of a large number of delegations, particularly from developing countries, hampers the universality needed for the court. And the Kenyan delegate even asked the General Assembly to make sure that all states, including developing states, would have enough resources in order to be able to send the delegates to participate in these negotiations. For Cameroon, the drafted statute of the ICC would be viable only if it was the subject of a widest possible consensus. Algeria warned that imposing temporal constraints on the negotiations would only jeopardize universal support for the court. Libya asserted that members of the judiciary of the future court should represent different legal systems. And Angola also shared the same sentiment by stating that the principle of equitable geographical representation should be observed, and the main judicial system should be represented in the process of nominating judges. So that's the universality theme coming again and again from African delegates during these negotiations. The other main theme was the independence of the future court. During the negotiations to create an international criminal court, whether at the meetings at the UNGA 6 committee or the ad hoc committee to establish the ICC or the preparatory committee or the Rome Conference, the court's independence was the most salient issue for African states. Algeria, Egypt, Ethiopia, Ghana, Lesotho, Libya, and Sudan were the African states the most concerned with the independence of the court. For instance, Ghana said that the International Criminal Court, while linked to the UN, must be totally independent in its functions. And as Algeria noted, the purpose of the exercise was to establish an independent and impartial court, immune from external influence. This concern was also shared by countries from the global south writ large. For instance, the non-aligned countries at a meeting in Colombia prior to the Rome Conference affirmed that the court must be independent of political influence of any kind, including that of the United Nations and in particular the Security Council, which must not direct or hinder the functioning of the court. The head of the Senegalese delegation at the Rome Conference affirmed that the ICC court should be independent of any political structure, including the Security Council and states. The South African delegate, speaking on behalf of SADC, called for a prosecutor that would have the authority to initiate investigations without interference from states or the Security Council, and a court whose independence must not be prejudiced by political considerations. To African states, then, independence of the court was associated with freedom from undue political influence, either from the Security Council or from other states. Sudan illustrated the independence of the court in terms of international politics, stating that, quote, the experience of mankind in the endeavor of establishing the League of Nations and subsequently the United Nations has shown that political considerations come into play in all circumstances, and that facts are colored in order to promote particular interest. The world's less powerful countries and those of lesser political, military, and economic influence have thus become wary of the exploitation of global humanitarian principles and objectives to serve the purpose of some parties rather than others, end quote. In terms of the role of the Security Council in relation to the future ICC, the International Law Commission in its draft statute had proposed allowing the Security Council to submit cases to the ICC. States such as Algeria, Cameroon, Gabon, Libya, Sudan, Tanzania were adamantly opposed to any powers of the Security Council to refer cases to the ICC. For these states, such a trigger mechanism posed a threat to the independence of the court and make it vulnerable to politicization. For instance, Gabon was, quote, astonished to see that the draft statute provided for the establishment of a tribunal whose operation would be dependent on the goodwill of states and whose freedom would be hampered by those same states and by the Security Council. For the Algerian delegate, giving the Security Council jurisdictional powers would not only seriously undermine principles of sovereign equality of states, but also jeopardize the independence and integrity of the court. And as stated by the delegate from Ghana, quote, it was of absolute importance to maintain the credibility and independence of the court in all situations. And he noted that the UN Security Council's political influence must not be allowed to undermine the court. And Libya vehemently opposed the proposal to grant the Security Council the powers to refer cases to the court, arguing that, quote, linking a political body such as the Security Council with a judicial body such as the future court would have the pernicious effect of shaking confidence in the latter's impartiality. And of course, the non-aligned movement concurred with that position. Now, the third and final theme that comes out of these deliberations from the African states' perspective was the need to have a court that would uphold sovereign equality. And this sovereign equality was, this theme of sovereign equality was overlapping with the court's independence. And both were matters of great concern to African states. Some African states, including Algeria, Guinea, and Sudan, for instance, explicitly based their critique of the formal relationship between the Security Council and the court on issues of sovereign equality, arguing that this gives the members of the UN Security Council an advantage not enjoyed by other states that would be parties to the statute. Sudan expressed a fear that the court's capture by powerful states could be the result. For African states, the Nascent International Court provided an opportunity to address the structural inequality of the extant global order, which unfortunately the draft statute proposed by the ILC did not adequately address. For instance, Gabon criticized the preliminary ILC draft of the Rome Statute for lacking, quote, principles capable of guiding the international community in the establishment of a new world order. Its narrow scope and lack of vision of the future were regrettable, end quote. Libya envisioned a court that could be relied upon to overcome situations such as political conflict and, quote, imbalances of power in the international arena. Senegal also viewed the future ICC as a project towards an international order that upholds sovereign equality. As stated by the Senegalese delegate, quote, the small, weak states needed an international criminal court to the mandatory jurisdiction of which all states, whether small or large, would be subject. And it is in this spirit that some states sought to empower the UN General Assembly rather than the Security Council. Because again, the way the General Assembly functions is much more democratic and representatives of the whole world than the Security Council is. And to conclude, the prescient concerns expressed prior and during the Rome Conference revealed a deep mistrust between African states and international law. Again, international law here in quotation marks. In the shadow of colonialism. Still, these concerns were summarily dismissed. And yet, 2 decades later, the current international legal order shows that African states foresaw its pitfalls and limitations. As William Chabas argued, the Rome Conference was an extraordinary exercise in international lawmaking. The resulting Rome Statute, which created the ICC, was welcomed with enthusiasm in a euphoric moment of promise of liberal cosmopolitanism. Yet the international legal order it helped usher in, brings forth the many failures to account for the vision that African states and states from the global south in general had proposed. As the court has been plagued by multiple crises and having only completed a handful of trials, convicting primarily rebels of African origin, it is clear that the ICC has not upheld its vow to confront, quote, the most serious crimes of concern to the international community as a whole. The Malabo Protocol, a project of creating an African Court of Justice, has resuscitated some tenets of that earlier vision that African states had proposed in the 1980s and 1990s. And I'll stop talking now. Thank you for your attention.
Thanks, Omar. We already have a question from Apollo Amoko. Apollo, go ahead.
Hey, Todd, can you hear me?
Yes.
Thank you. Thank you, Omar. Welcome back to UF in a manner of speaking. I really enjoyed your talk. I thought it was extremely informative. This is not a completely, it's somewhat inchoate of a question. I think you're dealing with a really complex subject that has very many moving parts. But yet I'm a little bit curious about whether the analysis couldn't be a little more critical of the actors that come in the name of African states or in the global south, because it's very revealing that you say that you've addressed the ways in which powerful Western nations objected to discussions of colonialism and so on, which seem somewhat puzzling because the jurisdiction, I imagine, wasn't going to be retrospective in punishing historical colonialism. But at the same time, the actors that were speaking in the name of the global south were, to a large extent, authoritarian regimes that were themselves brutalizing their own populations, even though they were using the rhetoric of universal law, so that some of the names that you were citing were representatives of Gabon and Libya and Algeria and Egypt, so that it seems as if there's also a lot of disingenuous rhetoric that was being mobilized by anti-democratic forces to use the rhetoric of colonial grievance. And so I guess my question is, how do we engage? Because even when one talks about colonialism, it's a kind of disingenuous for representatives of countries such as Ethiopia or Morocco, or even arguably the split between Francophone and Anglophone Cameroon. And the final point that I think I would make is they talk about engagement and participation, but how much of them actually engaged their own populations in meaningful discussion before they purported to commit them to an international legal order? So it's clear to me that the ICC is structurally defective and it has been used in asymmetrical ways against Global South, but it seems as if the analysis also has to engage critically with the representatives or so-called representatives of the Global South. Thank you. I hope that was clear.
Yes, thank you, Dr. Amoko. That's a very good comment and a good question. And I do agree with you that these African states oftentimes held these positions because they were self-serving. And in that regard, there is nothing peculiar about African states. I do make that argument in the book that all states engage international institutions in a self-serving manner. And there is nothing inherently unusual about African states trying to do the same with the International Criminal Court. And I do agree with you that we're talking about the 70s, 80s, and 90s here. So in many African countries, the rule of law was not that prevalent. A lot of these leaders who had sent delegates to these meetings were oppressing their own people. So that is true. But where I mean, the argument I try to make here is not necessarily taking what these delegates were saying at face value, but trying to see in what ways do these positions that they held in the international arena were informed by the experience of African states with colonial domination and also the Cold War rivalry. And in that sense, what they tried to envision, the kind of international legal order that they tried to see come out of these negotiations, were one that was informed by that experience. One example, in 2014, in the middle of this contention between African states and the ICC, the African Union tried to move towards creating a criminal court, a regional criminal court for Africa. So in addition to the African Court of Human and People's Rights, they decided to add one institution that would be similar to the ICC for African states. Now, instead of just replicating the Rome Statute, what they did was expand the list of crimes that they include in the jurisdiction of this future African court. And the list of crimes that they put there is informed by their experience as Africans, but also the concern that they do have. For instance, mercenarism is part of the list of the crimes that the Malabo Protocol has put forth. Destruction of the environment, pollution, child soldiers. So this list of crimes is the same one, basically, that they had tried to get the International Law Commission to adopt in the draft code in the 1980s. Because again, for African states, these are crimes that they want to make sure they're able to deal with. Now, it's not, I mean, it's not just all about ideals and everything. And of course, there are a lot of problems even with this attempt to create an African court, because in that same Malabo Protocol, they have decided that they will grant immunity to heads of states and senior officials. So the future African court wouldn't be able to prosecute African heads of state, for instance. So in that sense, I do agree with you that it's also self-serving.
Apollo, did you have a follow-up question there? I see your hand is still up.
Oh, sorry. Thank you very much.
Okay, do we have another question or comment? Let's see. Okay, Paul Magnarella, go ahead, Paul.
Can you hear me?
Yes.
Oh, great. Thank you for your presentation. It was excellent. You covered a lot of ground. I just wanted to mention one part, however. The African states, as you said, wanted to separate themselves, or they wanted the court to be separate from the UN Security Council. The UN Security Council actually is the enforcement mechanism. Without it, the court could not really enforce any decisions it makes. See, that's one of the important roles of the Security Council. It would have to rely on governments to enforce the court's decisions. But if it's heads of states who are being tried, the governments are hardly likely to do that. That was my comment.
Thank you for the comment. Yes, the Security Council is the enforcement mechanism of international politics, especially when it comes to peace and security. However, the way that the International Criminal Court ended up being created resulted to a different kind of relationship between the court and the UN system in general, because the ICC is not a UN court, unlike the court for Yugoslavia or Rwanda, for instance. So the ICC does have a working relationship with the Security Council, but it is not a UN court. And the enforcement of ICC rulings, it does not come out of the Security Council, but rather out of the states that are parties to the ICC. So if you are a member of the ICC, then you are bound to the rulings of the ICC, and you must enforce ICC rulings, otherwise you would be in violation of the Rome Statute. If I may add also, one tricky thing about the Security Council also is that the Security Council does have the power to refer cases to the ICC right now, yet 3 of the 5 permanent members of the Security Council are not part of the ICC. Therefore, they're not subjected to the ICC jurisdiction, whereas they do have the power to refer all the states to ICC's jurisdiction.
Thanks. Paul, do you have any follow-up on that, or?
No, I just wanted to thank him.
Okay.
Thank you for your response.
Thank you.
So next question from Rhoda Darlington. Go ahead.
Hi, yes. Good afternoon. Omar, this is Rolda. I want to first say congratulations for not only your academic accomplishments, but your career accomplishments and your book. Such a wonderful um, blessing to be at a reading like this so that we can all be aware of what you're doing with your career as you move ahead. I want to apologize in advance. This is obviously not my wheelhouse. And so if I ask a question and the vocabulary is not precise, I hope you will still be able to understand my question. I wanted to know if you could expand on this concept of jurisdiction or adjudication concerning colonialism as a crime. How would it work, or how would it function as a tool if it were the case that the ICC were to take on colonialism as a crime? Would it be retroactive? What would the crimes of colonialism look like? Who would be in charge of the punitive measures that were to follow? I think it was great that you mentioned that the ICC kind of has its own um, membership ideals where if you're a member of the ICC, that means that you need to follow the rules of the ICC and follow any rulings that come down from the ICC. But what does it look like if colonialism were a part of these? Would I guess it would be 5 punishments or 5 crimes? How would that actually work? How would that be applied? I guess is my larger question.
Hey, Rolda.
Hi.
Thanks for the question. Good to hear from you again. Rolda was my good friend, colleague, and neighbor in Gainesville. Yeah, there is, well, I'll evaluate the symbolic aspect of this first and then go to the more substantive part of it. So the symbolism of having colonialism codified as an international crime of concern to the humanity is a big thing, especially for states that were subjected to colonial domination. And for states that were colonial power in the past, they wanted to resist that. So that's what explains these positions that Western European countries took in trying to make sure that colonialism and all the kind of crimes are removed from the draft code. Now, the codification of these crimes is important in international law. This is how the international law comes to be. For instance, after World War II, the international community got together and decided to put together a mechanism that would codify genocide as an international crime, which later was adopted through the Genocide Convention in 1948. Apartheid was also codified as an international crime through the convention in 1974. So this is how the international law is made, basically by codification through these conventions that then states get to ratify, and then there's a mechanism for enforcement. Now, how would it work in reality is it wouldn't be retroactive, but it would recognize the past actions as crimes, even if symbolically. If it is now, for instance, genocide was not codified as an international crime until 1948. But we can still refer to Nazi crimes as genocide, even though it's not retroactive and none of the leaders of the Nazi regime were tried for committing genocide because that crime was not codified and did not exist until 1948. So I hope I answered the question.
Yeah, I really appreciate it. I was really concerned about the retroactive implication of it because, I mean, it seems like every nation state would be implicated under a colonialism law. So I thought that was really an important factor. But thank you very much.
Yeah, but also if I may add something quick is that what some of the African states were arguing was actually that colonialism is not a thing of the past, that it may still resurface. And this discussion goes hand in hand with the codification of aggression. States spent a lot of, even when they created the ICC, aggression was included in the Rome Statute, but they couldn't agree on how to define it. So they pushed it back until 2010 at the Kampala conference, trying to come to an agreement of how to define this. And interestingly, Morocco, for instance, were in favor of removing colonialism from the draft code. I could probably guess that that may have something to do with the Western Sahara situation. But in any case, some states were arguing that colonialism is not necessarily a thing of the past.
Right.
Thank you. You have a question from Caroline Butler. Go ahead, Caroline. I think you're muted.
Oh, are you there?
Yes, you're good.
Nangadef Omar,
Angifi Nangadef.
Maifi Jamrek. I have a question about the enumerated acts of genocide under the Rome Statute, and whether you think those can capture some of the acts committed by colonial regimes. I think there's been an expansion of what may be considered acts of genocide. It's been expanded to include sexual violence, I believe, under the Rwandan tribunal. So I was just curious, in the absence of colonialism and in the absence of crimes like ecocide, how the crimes that are already established under the Rome Statute could capture some of those acts that maybe would fall under more strictly the crime of colonialism.
Yes, thank you. That's a very good question. And as you mentioned, colonialism or colonial domination could be viewed as a crime, but also it could be viewed as an umbrella under which a lot of other crimes were being committed, whether it is forced labor or ethnic cleansing or displacing populations or genocide. So all these crimes could be occurring under the general umbrella of colonial domination. And you are right, these crimes have been included in the Rome Statute as war crimes or crimes against humanity, and potentially the ICC does have jurisdiction over these crimes when they committed. And as you know very well, the ICC's temporal jurisdiction extends only to whatever crimes were committed after July 1st, 2002, when the Rome Statute entered into, when the Rome Statute started being operational. So any crimes that were committed, either whether under colonial domination or not, prior to 2002 would be outside of the scope of the ICC. Therefore, there would have to be an ad hoc mechanism to deal with those crimes. But yes, you are right. There are a lot of crimes that could fit under the umbrella of colonial domination, where the ICC would have jurisdiction because they have been included in the Rome Statute.
Okay, thanks. Do we have another question or comment from the floor? We've got about 15 or 20 minutes, so. But maybe you've swamped them, Omar.
Well, the interesting thing is that I cannot see who's in the room. That makes it interesting from my perspective.
All the focus is on you. Well, if nobody else has a question or comment, I want to thank Oumar for his time today and for a great talk. It's always a pleasure to have our alumni come back and join us. We'll have more coming down the road in the coming weeks. So thanks again, Oumar, and I wish everyone a pleasant weekend.
Thank you, Todd, and thanks everyone for coming to the talk. Take care.
Bye-bye now.